Association. We're a member organization. We claim to be the largest court association in the world with over 1,800 members. The board of directors and the officers of the organization are all volunteers, as are our panelists today. We do this because we believe in educating court professionals and advancing the court professional career. Next, please. This is a picture of our website. Our website is NACM.net. That's NACMNET.org. You can go there to get information about conferences, about the core itself, which we'll be talking about in a second, to get some resources. And also, we'd love to have you join some of our committees. We have a whole bunch up there. There's explanations up there. There's links to the heads of those committees. If one seems interesting to you, just please go click and say hello to the chair or vice chair of the committee, and they'll be happy to tell you how it works and when you can join for the next meeting. Next, please. So we have a variety of member benefits, this webinar being one of them. We have a lot of people involved, as I said, 1,800 folks, so you can gain experience by meeting people, going to conferences, attending webinars, reading publications. We create court guides every year. Those are up on our website as well. And there's a variety of resources there as well. You also get a chance to kind of expand your resume and your experience because you can be an instructor. We have volunteers for our conferences to give plenaries or breakouts, and those, of course, are national events, so you get a little bit of exposure. We also create various white papers. The guides, as I mentioned, are something you could join in on, and just generally learning about an area, diving into it, and really get you up to speed and that help you shine back home. We also have a mentor program, and I'll point out Cheryl has been kind of a key person there, but if you either want to be a mentor for a newer person in the system, or if you need a mentor, you can reach out to us, membership committee, and they will hook you up with a mentor. And that's a nice program that's been going for a while. All right, so what is the core? NACM, in its 40-year history, and this is our 40th anniversary, has been working on core curriculum for a long time, almost that entire time. We now have 13 different curricula, and we have grouped them into these areas. There's a vision, principle, and practice area. We actually have made a decision as a board to add a 14th curriculum in the next year or so, which will be focused on IT and how that works for court managers. So there's various ways you can join in to experience core products. You go to the next one, please. The purpose of this program is to strengthen core professionals. It's to provide greater exposure to the curriculum. When you do reach certain milestones, they will get recognized at our conferences. And as I said, there are 13 of those. So how do you participate? Well, you can go to a live session at one of our conferences. You can watch videos that we have on our website. You can attend webinars like this. We tend to put on about 2 of these a year. And you even are allowed to self-study if you want. Once you've done that, if you want credit, you have to complete what we call a structured response test. In fact, there's going to be a link put in the chat for the structured response test for this session that you can fill out. Now, this is a member benefit, but we do allow non-members to participate and get credit. It's $10 a class, so to speak. Once you've turned in your SRT, as we call them, a work group will look at it and see if you've made the points that we're looking to see. If they do, then you're qualified for core credit. Next one, please. And you can get various certificates along the way. If you take one class from each of the different areas, we call you a core explorer. That gets you a certificate. If you finish all the competencies in any one of the modules, you can become a specialist in that area, and that also gets you a certificate. And if you complete all 13, and then there's a small project at the end, you can become what we call a core champion. Court champions are recognized at annual conferences and mid-year conferences, and it's just a real nice thing to throw on a resume, showing you've done the work to learn all about our profession and, to get the credit you deserve. All right. Well, that's probably enough of me talking. I'm going to let the two panelists introduce yourself. Now, there's a couple of things. As I said, we're going to put the link for the stress response test in the chat. If you've got a question, you can throw it in the chat. I'll be monitoring it, and when I can, I'll try to bust in without being too disruptive and get your question answered. And I'm also going to throw my email in the chat because there's another way to get core sessions. We do provide them live for jurisdictions or for court associations. There's some, there's more, obviously a lot more to that, but if you're interested in that at all, you can write me directly. I'll throw my email in the chat. Anyway, without further ado, I give you our panelists.
Thank you, Greg. Appreciate it. Hi, good afternoon. Welcome. And we are here to talk about court operations and court management, which can be everything. But let's kind of go over a little about what Greg was saying with the core champion modules. You have the 13 modules. The 13 competencies with 3 modules. You've got the vision, the principle, and the practice. Today, we're going to be talking about the practice, and we'll go into more detail, but I wanted to kind of tie it a little bit together for you. I am Dawn Palermo. I am the court administrator for Jefferson Parish Juvenile Court. I'm also a board member and the communications committee chair. So I welcome you, and I hope that you will consider joining NACM if you're not. If you are a NACM member, I hope that you learn more and you want to continue with the Core Champion program, or you can reach us to find some other resources that we can help you out with. There's so many things that NACM has, and hopefully we'll highlight a few, and I'll give you another idea of where you can find some answers to some of your problems. So let's talk a little bit about core operations. It is not independent. It is intertwined in all of these other things. You cannot talk about your operations of your court without talking about how it's going to impact your budget or how it's going to impact your workforce. Or it may be you're going to need more public relations. You're going to need to change your case flow. You might have to change your IT. Everything's connected. So just because we highlight a few things today doesn't mean that's everything. There's so many things that you're going to see along the way. It's dynamic. They all interplay within each other. And we could be jumping to leadership, which is in the vision module, because leading the court and handling the operations would fall under that. Or strategic planning, as you're going to hear later on, which is such a key into the managing the day-to-day and future operations of the court. So I welcome you again. Please feel free to put stuff in the chat. We're going to be running a few polls. Let us know if you're having any glitches. And I'm going to turn it over to Cheryl to introduce herself.
Good afternoon. I'm Cheryl Stone. I have worked in 5 unique jurisdictions, including state, local, and tribal courts across 3 different states. I'm a fellow of the Institute for Court Management and a longtime NACM member. I served on the NACM board from 2021 to 2024 as a director and led the membership committee for most of that time. As Dawn indicated, court operations serves as the fundamental backbone of our justice system, shaping both the experiences and perceptions of those who interact with the courts. Every role and responsibility within court operations is indispensable, contributing to the overall functioning and the effectiveness of the judicial process. For instance, clerks often serve as the first point of contact for court users, setting the tone for their overall experience. Additionally, the accuracy of court records is critical to ensuring fair and transparent legal proceedings. While we all share a commonality in the managing of these complex environments and organizations, the nature and the range of functions can vary significantly depending on your court jurisdiction. For example, an appellate court might look very different in terms of operations management, as well as from a general jurisdiction court. But they still face the issues of public trust and confidence and strategic planning and court governance. General jurisdiction court will look very different from a tribal court. And then there are a lot of differences between federal, state, and local courts in terms of what types of court operations have. So we have a lot in common. And when you get into the details, into the seeds, into the details of each of our operations, you'll see that there's also quite a bit of differences in how we put to practice court operations. Dawn, I think we can go to the next slide.
You ready? Okay. What we're going to do next is we are going to run a poll. And we're curious what you think of when you think of court operations. So I'm launching the first one. Hopefully you can see the poll and you can start answering. Okay. I'm getting responses, so it's working.
ADR, in case you're not familiar with it, is alternative dispute resolution, and we used an acronym in question 2. It's alternative dispute resolution.
Okay, they're still coming in, so. And you can put the questions in the Q&A box too, if you have them throughout. It appears that that is working and the chat is not right now. Okay, it looks like everything slowed down, so I'm going to end the poll. And I am going to share the results. Okay, so basically you can see it includes everything. So the answer is there is no right answer. It can be anything depending on the day, depending on the task, depending on the fire you have to put out, because court administrators could also be considered firefighters some days. But as you know from the title of our webinar today, we're talking about seeing the forest through the trees, which is another way to describe that you could be doing anything and everything. So what we want to talk about now is, you know, some of the foundation, which is your seeds, some of the day-to-day operations, which is your weeds, and then the trees, which is your support and what you need to be able to do everything that is encompassed in that. I'm going to stop sharing our results. Okay. All right, so that brings us to our learning objectives today. If you were to go pull up this core curriculum on the core website, under the NACM website, you would see that it's intensive. It will take you many, many hours, longer than today's webinar for sure. But here are the key learning objectives that we're going to cover. The first off is to recognize the operations management within your court and your organization. So when we're talking about that, those are the seeds that we're planting. Then we're going to identify court operations and services and programs. Those are your weeds. That's your day-to-day stuff. That could be your contracts, your providers, your specialty courts, your treatment programs, your probation programs, whatever it may be. Then you've got the trees, which is your understanding your infrastructure and your support that your court needs to handle all of these tasks. Court operations keeps everything going and allows us to function because we're equipped with the various things that we need, the supplies, the staff. the equipment, the security. So we just talked about it. We handle so many things that it's hard to be an expert in everything. So some assistance is always needed and some support from other people, but also some best practices, which is where we'll bring you back to the NACM guides and things like that. You can go back to this curriculum and they'll go into much more detail than we're going to go in today about some of the operations. Now, not all courts are going to handle the same thing. So there are going to be things that we discussed today that your court might not, or your position doesn't handle. The clerk of court could be independently elected and you don't need to worry about the record. You might not have to worry about the building or the security, that's the municipality's problem. Or you may have to worry about everything. So everyone's a little bit different, but most courts have some key similarities that can be helpful to each. And then we're going to talk about all the planned and very much the unplanned thing. Let's go back to the kitchen sink. You could have a leaky sink today. You could have a hurricane coming tomorrow. You had a fire that destroyed your records. What do? Those are the things that we want to try to help you out with. So that is going to start our competency, and Cheryl's going to take it over.
So I'm just going to do a brief overview of the areas, and then we'll dive a little deeper. And the reason that we're doing very high level coverage of these operation items is because each of the competencies could take up to 4 hours each if we wanted to get kind of into the weeds of each one of them. As Greg mentioned, there are longer sessions that can occur around each of these competencies. And the specifics of each of the areas may not apply depending on your court, just as Don explained. Your jurisdiction or your state may have different rules, laws. You may have jury trials or not. You might have an elected judge. You may not. Your jurisdiction might be limited to certain case types or civil case types, criminal case types. So there's quite a bit of differences. So we're going to try to keep it at a higher level. I'd encourage you to connect with courts that are in similar size and jurisdictions to talk about court operations and share information. I have found that most helpful during my career. So we'll begin by discussing services and programs for those services that are required statutorily, and then those that are required constitutionally or by federal regulation. I do want to point out that most of you would be familiar with the Bill of Rights for the United States. A lot of people don't know that there is a separate Bill of Rights called the Indian Civil Rights Act of 1968 that is unique to tribal courts and to Native Americans. And so there are slight differences to those in terms of what the federal regulations or constitutional, U.S. constitutional rights there are for Native Americans and tribal courts. It leaves the ability for tribes to have sovereignty of their nations. So as you look at these areas, first, the services that are required by Constitution, the jury function, the indigent defense function, language access resource, and making a court record, you'll if you think about those, you'll find that they do cross over like we talked about earlier. You can just drop into the chat for those first 4 items under the services required by Constitution. What types of things in those areas affect case flow management? What types of things where is HR utilized into those? Succession planning, fiscal administration, for example, indigent defense, there's often budget concerns, there's often contracts that need to be considered. High profile cases, there needs to be some payment functions, right? All of those are in the core of the operation management. Information statistics includes accuracy rates and the complexity of the cases, maybe a jury toolbox, right? Performance management and research can all cross over into that as well. We move on to programs and special services that are not federally regulated or required by Constitution. probation services, problem-solving courts, alternative dispute resolution, court-ordered services. Will cover some details in those areas as well. John, we can go ahead and move to the next screen, access and direct services. So we'll follow those first two areas of the competencies by some information on access and services, self-help services, particularly for self-represented individuals. But self-help services are also, I think, an important component of your family law area. If that's an area that you work in. Access for persons with disabilities, which is federally regulated, but it's a direct service component of court operations. And then there's, of course, what happens in the courtroom, court recordings, and all of this is impacted again by caseflow management, human resources, succession planning, fiscal administration and budgeting, information statistics, and more. Information technology, continuity of operations plans. How many of you have a COOP for your court, or how many of you know what the COOP is for your court? Is probably a better question. Facilities management and court security, which is super important. John, you have some experience or exposure to robots in courts, is that right?
Yes, we just finished the AI guide, and as part of it, the revision actually, and as part of that, there are many examples of robots that are being used in various courts to help with check-in, to give some information. Some of the things, cutting down on some of the phone calls and things, the general questions. So if you go to that AI guide, you can find the exact courts that are doing it. And one robot's named Gina. The other one might be Tina, but it's something close to that. So I welcome you to try to reach out and look in other ways. And there's also an AI guide webinar that you can go back to and review, and it'll tell you about it too.
Okay. Starting with the statutorily required services, we're going to just take a little bit deeper dive. If you want to go to the next slide. We're going to talk about jury services first. Jury provides a great example of that interplay with other competencies. It's public relations, because you're selling your community on jury services and encouraging them to appear. There's technology and jury management systems, and how do you get your list? How do you draw names? How do you seat jurors? Those types of things. But also the expectation of jurors and the expectation that they have for the use of technology. There's case management components to this, and communication with trial divisions, and ADA accommodations for jurors. So jury functions include a wide range and really impact court operations. You've got to have a way of obtaining a juror's list. You've got to interact with jurors and in a positive direction. They're not always so excited about jury service. There needs to be a program management and performance statistics, and National Center for State Courts has a great jury toolbox if you're interested in some of those performance measures and ways to analyze your jury use. You've got to have a way to schedule and excuse and provide extensions to jurors as needed and as allowed by your jurisdiction. And then using community outreach and education as a tool to reach potential jurors, and make sure that you have a representative group of people from your community who report for jury service. Source lists can come from different places. Some come from the DMV, not just those who are licensed to drive, but those who have ID also through the DMV. They can also come from voter registration, or a combination of sources as well. It's very different by jurisdiction. If you're a travel court, it might come from your membership, those types of things. Some potential challenges and opportunities in managing jury operations include juror bias in very small communities. How do you overcome juror bias when your community is, say, 200 people? Or what if your community is 1,000 people, or maybe, 1,000,000 people? There's a lot of different sizes of jurisdictions. And so how do you overcome juror bias when everybody who walks into the grocery store or that, you go to school with? Managing high profile cases is a big part of jury management these days. There's been a lot more of these high profile cases, and they can happen in small jurisdictions as well as large jurisdictions. So having a process for that. And there's some great tools, again, on the NACM website, resources, and then at the National Center for State Courts for that. Indigent defense services involves contracting in a lot of cases. Indigent defense can happen multiple ways. Your court may contract with indigent defense providers. You may have a executive branch function that oversees and even handles that. I've worked in both of those types of jurisdictions. Some important things to look out for in indigent defense services is, one, your budget, but also you want to make sure you're providing quality representation for individuals. You want to know what the attorney qualifications are. You want to have an understanding of the goal of indigent defense. You want to utilize appropriate review and assessment processes. Have a way to review your public defenders and evaluate your public defense program. There needs to be somebody identified as the overall has overall responsibility for the oversight. The court needs to have a process for appointing, and the attorneys need to have a process for identifying conflicts. And this overlays with your very much impacts your case flow management for your overall court. There's that tension between defense and prosecution and courts, and what is the most efficient process for those. And there's a lot of work that needs to be done in between those entities to have an efficient case flow process. When you are not properly staffed, when you don't have properly qualified defense providers, it creates challenges for your court, in your courtroom, and in your workflow for the court. I'm going to just pause right here and see, Greg, if we have any questions from the chat at this point about jury functions or indigent defense services. These are pretty broad areas, and I'm just covering them at a very high level.
I've not seen anything yet.
Okay, well, just drop your questions in the Q&A or in the chat, and we're happy to answer any detailed questions for your jurisdiction. I know I'm going kind of rapidly through these. Okay, and then language access resources. It's important for you to understand the demographics of your local area and to be able to identify what language services are needed, and that those language services are also provided for your indigent defense attorneys. The limited English proficiency requirements include assigning interpreters, maintaining lists of qualified interpreters in multiple languages, and implementing a language access plan. If you do not, how many of you, I would say maybe just by a raise of your hand in the chat, how many of you have a language access plan for your court? I hope we have many courts that have that type of plan, or that you've been thoughtful about how individuals who come through your court system need to be able to understand their process and your appearances in their language.
Cheryl, we do
Yes.
have a question. Someone's asking,
Okay.
please share the concerns that you have with using language lines.
Please share the concern about, I'm sorry, I didn't hear that.
Please share concerns you have with using language lines.
Language lines. Well, one of the things you need to consider is, do you have a certified interpreter? Many states, like Oregon, has a certification process for interpreters that includes ethics training and language that's appropriate in the courtroom for their certification. So when you get language line, you don't necessarily get a certified interpreter who's been trained in court ethics or in court lingo. And that can have an impact on a case if it's a serious proceeding that you're in. So language line, I think, is appropriate for maybe the front counter or things that are not substantive in a case if you're trying to communicate, but may not always be appropriate in the courtroom if you're having a trial or some other substantive motion language line, because you might not be getting a certified interpreter that's certified for legal purposes. Hopefully that answers the question. Dawn, do you have anything you want to add to that?
And we try to use it when we have no other option, because we do have, as in other people are saying, we have a language access program with the state Supreme Court. They certify them. So I need to go, that's got to be my last resort. I need to try to get certified first. Plus the judges can't stand it. My judges really want to see the person in court sitting next to the child or whomever they're interpreting for.
Yeah. Yeah, I think you just need to be aware of the risks, and depending on the court proceeding or conversation that you're having with somebody, and whether it's a language that is certified. You know, it's not possible to really certify every language or dialect in the world, and so sometimes you do the best you can, and your judge in your courtroom often makes that decision about how to qualify somebody as an interpreter for a court proceeding. So it can be used, it's useful, but I would use it with caution. That was a great question. I think it's important for court managers to be aware of different technologies that are available, about certification and credentialing, about the difference between spoken interpretation and written translation. Those are two very different things, and important to be aware of. And then there's different service points where you need, so in the courtroom, obviously you need interpreters, but also at the front counter when you're answering the phone, you may need interpreters outside of the courtroom for your indigent defense individuals. There's a whole lot of entry points where you may need to consider language resources. It's important to create a list of qualified interpreters. I think I mentioned that. And some people have staff interpreters and some people don't. They have to contract for them, or they create this list of uncertified interpreters. Okay, making a court record. Making a court record in the courtroom is often a court reporter or a digital recording system, or a combination of both. There are other methods as well of making a record, but record keeping also extends to your case file, which might be paper still in some environments, might be electronic, or may be a combination of both. A lot of courts have moved to an electronic type of management of their case management system, and accuracy in keeping those records and the input that you put in really can have a significant impact on the outcome of the case, on your case flow. Of course, the verbatim record is very important for appeal status. It is the record that you would go back to verify what you see in your case management system in case something was inaccurately input in there. It is the way that we review all of that transpires in the courtroom, including assignments, including any transcripts that need to be prepared, and including any orders that the judge may need to go back to and listen to prepare the orders for the judicial assistant. We need to do that. The quality of the recording is important, and background noise can matter. It's not as simple as just pushing the button on a recording machine. And what happens when you don't have a court reporter, or when you haven't pushed that button when you were supposed to in the courtroom for the recording? You lack the record that's needed for appeal. we can go on to the next thing. Okay. Next, we're going to talk about programs and services. This is one of my areas that I just love to talk about. So I'm going to try to be brief here. I could talk about this for hours. When we open this session, we acknowledge that every practice area we discuss may not apply to you. So for some watching, probation services may come under the executive branch. In New Jersey, it's part of the judicial branch. As an operations manager, you may or may not oversee this area. But you do interact. If you're a general jurisdiction court, if you have any kind of probation, whether it be bench probation that's monitored by your court, or it be formal probation that is monitored at a state level or some other way, you typically have some probation that you interact with. The probation services can consist of a variety of court-ordered actions under the direction of the probation function. Probation can sometimes, or pretrial can sometimes fall under probation, pretrial services. And so there's a component that may be trying to manage your jail population. They're two different functions, but oftentimes they fall under the same department because there's some commonality in the types of services. There can be, there's a monitoring of court orders and sentences through probation services. There's an assessment that is often given to people in probation services that determines what their service and treatment needs might be. There's an evaluation of their risk to the community, possibly if it's a pretrial service type of situation. And there's different types of monitoring. There can be electronic monitoring. There can be home detention. There can be various levels of check-in with a probation officer. And then if there's some sort of violation, that might come back into your court in terms of probation violations. I would be aware, make sure that you're aware of political types of things happening in your community that might impact your probation services and or your work with judicial officers. There needs to be a good trust building relationship between the court and probation services to make sure that the court orders are being carried out in the way that the court has ordered them. What also can fall under probation or pretrial services is a predictive risk assessment tool, or even services related to protecting victims. For example, there can be a lot electronic monitoring in a pretrial service case to protect a victim. I know that they were testing some of that and doing some of that in Washington state as well. Alternative dispute resolution. I would encourage you to think of alternative dispute resolution in a larger way. Oftentimes this means mediation. It can mean in a tribal court, it might be a peacemaking circle. I think there's also some courts in California, some counties that have peacemaking circles available. It impacts your case flow, and it can be a really a settlement conference, for example, in a civil case can be a really good way, or in a family law case, to resolve the dispute amicably without having to take up a lot of trial or court time in your court. I would make use of those, particularly as there may be some low-hanging fruit that you could use through this process. Small claims might be a great example of that alternative dispute resolution. The goal here is that you create a process whereby people have an opportunity to come to an amicable solution between the parties that is stipulated and agreed to, and then brought to the court to close out the case. There's typically no risk in these types of alternative dispute resolutions. If you don't settle the case, you go back through the normal court process and you can resolve your case in that way as well. Greg, any questions so far?
None for the group at the moment, no.
Okay. The other might be a restorative, there are a variety of restorative justice types of alternative dispute resolutions available. I know in Eugene, we had one that worked through the college campus. That was an alternative dispute resolution. I see someone has shared Alaska's language information in that chat. Some of the potential challenges for ADR, if you're not tracking them appropriately, they can kind of become out of sight, out of mind. And so it's important that you're tracking them to get resolutions. Sometimes these alternative dispute resolutions involve attorneys on both sides, and the outcome or lack of outcome or the timeliness of these meetings can get lost in translation. Yes, Greg?
We have a question. Can an ADR type of program be used to resolve criminal violations resulting from neighbor disputes?
Well, that's a great question. So that's kind of what I was referring to. And one of the things in Eugene, we coordinated with the DEPS, the University of Oregon, to have an alternative dispute resolution that revolved around restorative justice. And so it did have a lot to do with with neighbor to neighbor complaints around loud parties, but also involved other types of offenses. And so those I would really encourage. I think that the defendant in those cases who may have received a citation learns a lot about how to be a good neighbor and be responsible partier, if you want to call it that. And it has a great outcome. Neighbors get to know neighbors, and everybody's learning about how to amicably and responsibly handle those types of offenses. Don, do you have any examples?
We use mediation here for child in need care cases, trying to get the child in some sort of family placement. And if there were mixed outcomes, it really depended on if the family could even be in the same room together. If we couldn't get them through restorative justice to a point where they could be in the same room with each other, it didn't work for us. But when it did, we found somebody to handle the care for the child while the parent was working, maybe a case management plan for substance abuse allegations or something like that. So it helped out in many ways because the kid was not in foster care, and it was a more beneficial process.
Another option that some local courts use is community dispute resolutions. I've seen that used in neighbor-to-neighbor disputes where two neighbors just aren't getting along, and there may be some battling going back and forth. And so sitting down with a person who has expertise in kind of mediating those conversations and coming up with an agreement that can work out well. So if you have, I think we had a case where one neighbor forked another neighbor with a barbecue fork because there was this argument going on related to property lines or noise or something. So community dispute resolution can come in and help the two parties mediate that, and a case can end up getting dismissed or dropped as a result. Greg?
There's a question asking if you know of any ADR type situations that are used as the first part of a case as opposed to waiting for the case to actually get to the courtroom.
Sure. Yeah, I'm aware of some DA programs actually that offer that ability because they get the police report, they can see right off that it's a neighbor-to-neighbor dispute, and they might refer them first before filing the charge in the court. They might refer them first to some sort of community dispute resolution or alternative dispute resolution process. So I think that is most effective, actually, before you even get to the court, before you even create this court case or this record, to be able to resolve that dispute right off the bat is a great opportunity. Not every DA would do that, but it is great when they have a resource that they can refer people to amicably resolve those issues. Any other questions? This is an area that has really grows rapidly, and you can be as creative as you want, and depending on the partners and the stakeholders that you have, you can create some pretty great opportunities for people to resolve their citations outside the court before they're filed in court, etc. The next area is court-ordered services. We have the emblem of CHASA there. The court can appoint all different types of court-ordered services, guardian ad litem for adults, for children, in a variety of different types of cases. There can be psychiatric evaluations, there can be supervised visits, court-ordered treatment programs. There's a long list. I'm sure I haven't listed them all. You can type some more of those in the chat if you would like, but there's a variety of court-ordered services, and that requires you to have great community relationships with a variety of programs. Sometimes these programs are run by the court. Sometimes they are contracted by the court. There's a variety of different ways that they are set up. Sometimes there's professional guardians that the court might order there, and then there's a variety of ways that guardian ad litems are used or in the court system for both family court as well as in the probate area. Maybe you have some idea of other court-ordered services that you work with. We'll dive into specialty courts next, and there's a lot of court-ordered services involved in the specialty courts as well. So specialty courts includes a wide range of problem-solving types of courts. This can be a mental health court, it can be a drug court, it can be a community court. It can even break down your mental health court into those that are considered unable to aid and assist and awaiting further evaluation or to be restored. Some communities have what's called community restoration types of programs that require regular reporting to the court and regular engagement with mental health services in your area. These specialty courts often require a wide range of partnerships with community service providers, from children providers, newborn people who are experts in newborns, people who, like Boys and Girls Club, missions that might be in your area, homeless services in your area. I could go make a pretty long list. Specialty courts can be broken up into specialty areas like veterans courts. Veterans court may have a mental health piece and a addiction piece, but it may still only be just trauma informed, and how are you interacting in your life as a veteran and the impacts of that. There can be animal welfare courts, gambling courts, all different kinds, and a community court can include all of these different components. There's juvenile treatment courts, there's family treatment courts, there's adult drug treatment courts. All of these deal with a special niche of cases that are best served by putting them into a separate docket, giving them the attention that's necessary from the judicial officer. So they can be as little as a handful of cases or as large as entire dockets, just depending on your court and the types of problems you see in your community. Dawn, do you have any specialty courts in your jurisdiction?
Yes, we have our juvenile drug court just closed about a year ago, but we do have a family preservation court now for parents, substance abusing parents who have lost their children, and we're trying to reunite them before the deadline. So,
Yeah. And some of these can interact, like your specialty court may have a community service requirement as a result in their court program or court order. And oftentimes in courts I've worked at, we work with probation or with the local city on finding those community service projects so that people could get back to their community in the area where they offended, or get back in a meaningful way as part of their program. There's helpful websites. SAMHSA is a great website for substance abuse and mental health services. The Center for Justice is a great resource for specialty courts. Your local community dispute resolution center is a great collaborator for alternative dispute resolution options as well. I think it's important to talk about here, again, that this varies by your jurisdiction. This might look very different in a tribal or a sovereign nation than it would look in a municipal court or a state court. Each community of people have their own issues to identify and analyze. And I encourage you to use data when trying to implement any one of these options or programs at your court.
okay, we have about 10 minutes left, so you can keep putting the questions in there. But let's do a review of some of the access and direct services that the court operations could be handling. So it could be your family court services, your self-help, your law libraries. It is kind of determined upon what your court users need, what you need to provide for them. So how are you going to do check-in when they're coming in? How are you going to answer some of the questions without giving legal advice, which is always an issue? You can always find some of the self-help resources. I know we've had some articles in the Court Manager before. We've also had conference sessions. So there probably are some videos that can help you with that. The law libraries, judges still want books, things like that. How are other people handling the escalating cost in that area? Might be something you want to look into. AI is helping in several of the court users areas, like we spoke about earlier. The AI guide will be helpful. And when this question was asked earlier in our poll, 11% of you are using AI, 89% are not. So it's a growing area. There are going to be some more sessions to discuss this. So it might be something that you would learn, and it'll help you out in the future. Okay. So then you've got access to your building, access to your court cases. It encompasses a lot. First off, it would be ADA access for sure. Are they coming into the building? Do they need a special accommodation through Zoom? How are you going to handle this? What if that elevator goes out, which was a nightmare we've had before? You need to have a plan for how you're going to handle that. Are you going to move a courtroom downstairs when something goes wrong? What are you going to do when they need real-time translation? Can you provide it? Do you have the equipment now? Has your equipment been tested? Because maybe you didn't use it in a long time. Those are the things that as court operations, you need to be checking in on and making sure that you have a plan and getting through the day-to-day operations. Sometimes you don't even have time to think about it until the fire's here. So hopefully it will give you some time. You also want to start coordinating some of these things in the accommodations with maybe the municipality. Who owns your building? Are you accessing this building with other key stakeholders? You might need to have a meeting to discuss what you can and cannot do and who's going to access at which time, how you're going to handle the back ramp that you might not be able to use right now. But that's a quick view of those two. And then Cheryl's going to go over the courtroom operations and the records and files.
Okay, courtroom operations. This is where all the action happens, right? So this is where all of our work outside of the courtroom accumulates into this show, if you will. It's not really a show, but into the courtroom and the experience the individual has with the judge. So this is where your court records, your court recording, all of those things that your juries processes, everything kind of comes into here and plays out. Depending on your jurisdiction, it requires different levels of collaboration with different departments and different entities, including elected officials. It also highlights the importance of consistency in protocols and practice within a court. There needs to be courtroom protocols, and sometimes in a court with more than one judge, you have multiple courtroom protocols. If you have 14 judges, if you have 15, 20, or 30, you probably have that many different courtroom protocols for your courtroom. And that can include how jurors are escorted into your courtroom and how they're sit during the voir dire process and such. There is the overseeing of courtroom clerical staff, the recording of minutes in the court proceeding, the issuing of court rulings, notices, and forms. What do people leave with when they leave your courtroom? Assigning and training staff. Do you have staff that can cover when other staff are out? Or if the staff in the courtroom need a break. Ensuring all of the minutes are captured and recorded and everything that accurately in your case management system, that documents are filed, that exhibits are marked. That this can be, I've been in courtrooms where there was just one person who handled all of these, or sometimes there is, like Dawn suggested, an elected clerk of court where there can be two people in there, and those duties are shared differently in each courthouse, depending on the court, about what the clerk would, a court would handle and what the court clerk or judicial assistant who is in the courtroom is handling. There needs to be records management policies and overseeing the managing the records of the court, making sure that everything that is input into the system is accurate. And even if you are not the one inputting it, for example, if you have an elected clerk of court, it's really important that your court is still monitoring the accuracy of those records, because that's a direct reflection on your court and your bench, your judge, and your court staff, even though it might be a completely different entity that is doing the entry. But when the public looks at that, they're looking at the court as a whole. This directly ties into the purposes of court that are articulated by Professor Ernest Friesen, and you can find those on the NACM Court website. It's important that fines, fees, filings, exhibits, all of that are handled timely and appropriately and accurately, and coded appropriately. Often this dictates where money goes in our court system, that is dictated by statute in some cases. And then
we can move on. So then we move on to infrastructure and support. So we're starting to talk about information technology, which has been intertwined into everything we have done so far. When Cheryl was talking about going back to the data, that's probably in your IT system. Your payroll system is probably IT. Your court reporting system, your digital reporting system, your case management system, your records retention, all of that. So we have to have a strong IT support, and funding that is usually a huge burden for the court and can be a huge crisis for the court when it is not appropriately funded. So bringing us back to the purposes of court, we need to ensure that we are there for the public and prepared at any time, because the next thing we're going to talk about is continuity of operations. So it's a strong component that needs to have the resources, needs to be part of any strategic planning and part of any budget for sure. But in addition to just providing those services, we've got to worry about the backup. We've got to worry about the security, and if the system's hacked, if the system has the resources that we can work remotely when we need to, when there's an emergency. There's so many things to consider when it comes to this, and the court manager might not be responsible or even have the authority in all of these situations. It's going to be working with all the key stakeholders and making sure they understand that our court has to perform. It doesn't matter what happens, what natural disaster, what pandemic, we got to go on. The show goes on for us. And we did an incredible job during the COVID. We were still working when others had to shut down. We had to find a way to provide justice for our citizens. Now, when we're talking about continuity of operations plan, that's just it. What are we going to do when an emergency comes? You need to plan for the little things, like, you know, you might have several people out with the flu today. What are you going to do for workforce? But you need to plan for the big things. Your computer room catches on fire tonight. Do you have a backup plan? Can you upload that server? Can you be ready to go the next morning for court with all your dockets? A hurricane's coming. You're going to have to work off site, or you're going to only handle key items because everybody's evacuating. Do you have a plan? Do you know how to get in touch with your employees to tell them it's time to come back, or to tell them to locate to a different building? Do you have the supplies that are going with them that they need in the time? Can you pay your bills while you're gone? How much are you going to pay in payroll if it's an extended crisis? Are you going to provide full-time benefits and pay during that time, or are you going to be scaling it back? Because if so, you need to put that in policies. You need to think about cyber incidents and what might occur with that. I saw in the poll that most of you have a court continuity of operations plan. Hopefully it's updated. Hopefully your staff knows about it and they know where to find it, whether it be on your website or on your intranet or whatever. For my court, we roll it out every June, a new plan. The staff has to sign off. They also can get it electronically. And I have an emergency website that's how they check in, because unfortunately we deal with a lot of hurricanes. So that's their way of checking in, because their location could change from week to week, day to day. So those things help. But as court leaders, your role is to provide the leadership in this, to the calm, the understanding that you know there's so much going on in that time, but this court is still going to function and your job's still safe. And to serve as a source of critical information, because you're going to have to talk with other stakeholders and make sure that they know what's going on. You're going to have to provide responses to the public, which could be going back to public relations, and the NACM media guide might be helpful. You need to notify the media to get the message out where these court services are going to be occurring. And you also need to provide all of those details when that emergency strikes. The court is closing on such and such a day. We will reopen on this day. So you're responsible for a lot, and every stakeholder has a role, and every staff member has a role. So you want to touch that. All of this helps us keep with the principle of providing public trust and confidence for everyone, that the justice system works. So think about how you want to handle that. Look into some NACM guides. There is one on emergency preparedness, disaster recovery, and business continuity. That can be helpful. The AI guide can be helpful for that too. Then that brings us next into the infrastructure and support. So you have the facilities management. Okay, this is literally the kitchen sink we talked about at the start. It's leaking. What are you going to do? Who do you need to talk to? Are you in charge of it? Do you have the budget for it, or is it the municipality? You may have to go and speak to other people And you might have to stress why something's very important to your court and why your job can't be done, and that you can't just wait to fix that leaky window. It also has a little bit, it intertwines with court security because it is the building. But the success of all of it is based on strategic planning. You need the time to be able to plan for the future. Your building's going to wear down, your paint's going to wear off, something's not going to work, the chiller's going to go out. It needs to be refurbished and replaced in a key time. So you probably do want a maintenance schedule that you're agreeing with your key stakeholders on and you're working towards, because that's the goal. So hopefully you're not without air conditioning one day. All right, court security. So the courthouse has to be open and available to the public, but we also have to keep everyone safe, employees, the public, the judges, everything. We all know that the threats have increased. For federal judges, there's been over a 400% increase in threats since 2015, and everything is growing. So NACM has created a court security guide that has been revised. We had a webinar last month that can help. We also had a few conference sessions, and we had a webinar a few years ago that can really help you. It can give you the ideas. You go in and redo your courtrooms. Do you need Kevlar in the judges' benches? What type of glass do you need at the front door? What type of security do you need at the front door? What are you searching for? What do you need? Even the assistance with should cell phones be allowed in your building? Should you make people take off shoes? All of that. There are some resources out there to help you explain that. And then setting up your security committee, which is going to be comprised of other stakeholders that utilize your building, you're going to want to look at. But look for all the NACM guides for that. That would probably be the easiest way to get to some of these questions and start you off on that path. Okay, so to summarize this, so we have identified the court's functional requirements to perform their daily task. We have developed and managed the contracts and the things to provide the services that we need. Plus, there's probably so many other things that we haven't even touched on today that you do. There's so many components that are required in your job, and there's so many laws and rules, and then you have your own court's rules to play into this, not to mention what the auditor wants this year. So all of those things to consider can be overwhelming, but there are some great resources out there that we hope that you would look into and you'd be able to find them, and we can put you in the right direction. And Cheryl, do you want to go over the apply and recognize?
Sure, I would just say that your laws are always changing. Court rules can change. Policies and procedures could be changed depending on them. So always make sure that you are looking at updates to law, updates to court rules, applying those to your court operations as appropriate. And then recognize and response to demographic and other trends. Make sure that you're paying attention to your community, to your state, nationally about what may be going on in terms of court functions, in terms of court technology, in terms of how interpreter services are delivered, and understanding maybe the crime in your area and the appropriate response from the court for those in terms of sentences and alternatives for programs. Those types of things. So always be kind of in touch with the data, in touch with the community, as far as will make sense for your court, continue to go out from there, and then make sure you're applying all of those changes that occur over time. Particularly legislative changes can have a huge impact on your court operations.
Okay, so that brings us to the end. So we've talked about the seeds, which is the operations management. We've talked about the weeds, your day-to-day stuff, and we've talked about the trees, which is some of the strategic planning and everything. Below are listed the speakers. Ellen was unable to be here today, but she is an excellent resource. And feel free to reach out to her with some questions. She has some documents to share too. Remember to go to the NACM website. There's a wealth of information. I probably forgot to mention that there's a ton of court manager and court express articles that probably can be helpful. You can also search on the website and it'll bring you to those things. You can also go back and look at some old webinars. You can look at conference sessions, and the store is where you will find the guide, the NACM store. So what's coming up with NACM next? Well, on March 27th at 3 p.m. Eastern is the Federal Courts Roundtable that membership committee is going to be putting together. That is something that you do not have to be a federal court manager to participate. Last month was the tribal courts, and it was extremely interesting, and there were a lot of things that could be takeaways for any type of court. So I welcome you to do that. Look for the email. It went out a few times, and you just need to register to get your Zoom link. Then as for webinars, the next webinar we're going to have is going to be June 5th, and it's Tyler Technologies. We have our July annual conference in Omaha, Nebraska. We invite you to. And then April 25th is when the next Court Express, which is our newsletter, comes out. And June 3rd is when the next Court Manager, our journal, comes out. So we hope that you will look into all of that. And we thank you for joining us today. I'm going to see if there's any last minute questions. Anything, Greg, that you need?
Not at the moment, not seeing anything.
Okay, great. Well, thank you very much.
Thank you for attending.
Appreciate it. Bye-bye.